Good morning. Before we begin today's meeting, I'd like to observe a moment of silence for those who lost their families, who lost their lives at the Navy Yard on September 16th. As we gather here today, let us remember our fallen neighbors who left us too soon and their families and colleagues. I would ask now that we pause for a moment in tribute to them. Thank you. And once again, good morning, and welcome to the August 2013 meeting of the Federal Communications Commission. Madam Secretary, would you please introduce our agenda for the morning?
Thank you, Madam Chairman. Good morning to you and good morning, Commissioners. Today's agenda includes 3 items for your consideration and 1 presentation. First, you will consider a notice of proposed rulemaking to accelerate deployment of wireless infrastructure while at the same time appropriately protecting the nation's environmental resources. Second, you will consider a notice of proposed rulemaking regarding the UHF discount to its national television multiple ownership rule. Third, you will consider a notice of proposed rulemaking that seeks comment on proposals to improve consumer choice and facilitate improvements to the resiliency of mobile wireless networks during emergencies. For your final presentation today, you will hear the latest update on progress towards the upcoming October 15th through October 29th, 2013 open filing window for applicants seeking to operate new low-power FM radio stations. This is your agenda for today. The first item will be presented by the Wireless Telecommunications Bureau. Ruth MILKMAN, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Ms. MILKMAN, can't renaming you today. Good morning.
Good morning, Madam Chairwoman and Commissioners. Over the past few years, the Commission has taken a number of significant steps to reduce barriers to investment in wireless facilities. Today's notice continues that effort by proposing measures to expedite the environmental and historic preservation review process for new wireless infrastructure and by providing additional clarity regarding state and local review of wireless siting applications. The proposals discussed in this notice are the result of collaboration with the wireline, media, and public safety bureaus, as well as with the Office of Native Affairs and Policy and the Office of General Counsel. In addition to those at the table, I'd like to thank the other members of the Wireless Bureau team, including Jessica Allman, Neshe Gundelsberger, Manya Baghdadi, Juan Kim, Joyce Jones, Don Johnson, Steve Del Sordo, Sarb Chabra, and Ivy Harris. With me at the table today are Jane Jackson, who is Associate Chief of the Wireless Bureau, Jeff Steinberg, Deputy Chief of the Spectrum and Competition Policy Division, Peter Trachtenberg, Associate Division Chief, and Michael C. Smith, who is a Program Analyst in the division. Michael will present the item.
Good morning, Madam Chairwoman.
Good morning.
Commissioners. This morning we are pleased to present a notice of proposed rulemaking addressing opportunities to promote the deployment of wireless infrastructure. Specifically, the item before you seeks comment on 4 major issues regarding the regulation of wireless facility siting and construction. First, the notice seeks comment on measures to expedite the Commission's environmental and historic preservation review of proposed deployment of small cells, distributed antenna systems, and other small-scale wireless technologies. These technologies, which can be deployed indoors or on short structures such as utility poles, may have minimal effects on the environment. The notice, therefore, seeks comment on a number of options for expediting or tailoring the review process, including excluding some or all of these deployments from review. Second, consistent with an interim waiver the Commission adopted in May, the notice proposes to adopt a narrow exemption from the pre-construction environmental notification process for certain temporary towers. The notification process generally requires a 30-day period of public notice for proposed towers that require antenna structure registration. However, carriers often face a need to deploy temporary towers with very little advance warning, for example, in response to disaster or other newsworthy event. The notice tentatively finds that the proposed exemption will help ensure providers can meet these unanticipated short-term needs. Under the proposed exemption, eligible towers must meet specific criteria that should minimize the potential to cause significant environmental effects. Third, the notice seeks comment on rules to clarify and implement the requirements of Section 6409A of the Middle Class Tax Relief and Job Creation Act of 2012. Under Section 6409A, a state or local government may not deny and shall approve any eligible facilities request for a modification of an existing wireless tower or base station that does not substantially change the physical dimensions of such tower or base station. Because most of the terms of the provision are undefined, the notice seeks comment on rules to clarify the provision's meaning. The notice also seeks comment on how to encourage ongoing efforts by local government and industry representatives to develop best practices for applying Section 6409A. Finally, the notice addresses certain questions or disputes that have arisen under the Commission's 2009 declaratory ruling, often called the shot clock order, which established presumptively reasonable time periods for local review of wireless facility siting applications under Section 332C7 of the Communications Act. The notice also seeks comment on whether Section 332C7 limits local authority to establish preferences for siting facilities on municipal property. The Wireless Telecommunications Bureau recommends that the Commission adopt this notice of proposed rulemaking and request editorial privileges. Thank you.
Thank you, Mr. Smith. And now we will entertain comments from the bench. Commissioner Rosenworcel.
Thank you, and thank you earlier for that moment of silence. Spectrum gets all the glory, but the unsung hero of the wireless revolution is infrastructure, because no amount of spectrum will lead to better wireless service without good infrastructure. Today, however, the Commission gives facilities siting its proper due. In this rulemaking, we consider how to streamline our tower siting rules to facilitate infrastructure deployment, particularly in those cases where new facilities have minimal or no impact on the local environment. We ask about speeding approvals as we move from macro towers to micro cells. We consider how to expedite approvals as we move from permanent structures to short-term facilities. We also ask how to better define our rules for co-locations when new antennas do not require new structures, but can be appended to already existing ones. Down the road, these infrastructure issues become even more critical, because what lies ahead is much more than the recent explosion of wireless phones and tablets. The Internet of Things is around the bend. We will have 50 billion machine-to-machine devices communicating wirelessly by the end of the decade. The complexity of new machine-to-machine deployments, however, is not just some far-off thing. It is already happening. Although not specifically addressed here, consider the Rail Safety Improvement Act of 2008. This law requires the deployment of positive train control systems on major freight, passenger, and commuter rail systems by the end of 2015. Positive train control involves computers on board trains that communicate wirelessly with wayside units along tracks. In turn, these units relay signals back to a central dispatch unit and provide essential information about location, speed, and safety. To meet this deadline and improve rail safety, positive train control technology requires the deployment of tens of thousands of new wireless towers. This agency can take steps now to get this infrastructure in place and on the ground. To do so, I would like us to review tower applications in batches, so we treat deployments similarly and we process them fast. That way, the naughtiest applications do not hold up broader deployment. Furthermore, I hope we can find ways to prioritize our review of towers so that we can enable early testing. Finally, to the extent that deployments occur on tribal lands, all of these efforts must proceed in a way that honors the principles of sovereignty and federal trust responsibility. In the end, positive train control is only one example of the need for this agency to update its facilities siting policies to reflect the emerging reality of new wireless deployments. But back to the proceeding at hand. Though spectrum usually gets the spotlight, for the wireless show to go on, it is infrastructure that requires our rapt attention. Today's rulemaking provides that attention, so I am pleased to offer my support. Thank you.
Thank you, Commissioner. Commissioner Pai.
Thank you, Madam Chairwoman. In July of 2012, I met with some entrepreneurs in San Francisco who were developing cutting-edge applications for mobile devices. I was very impressed with the things they were working on, things like instant video optimization and cloud computing. But what I found most striking, and not in a good way, was the response to a question about bottlenecks in the wireless industry. They brought up the usual suspects, like the availability of spectrum, but they also mentioned how ridiculous they thought it was that they couldn't get good mobile reception in their own building in the heart of San Francisco. I asked them why, and they said that regulations made it nearly impossible for any wireless company to deploy more physical infrastructure in the city. So, what did these innovators do? They innovated. On the roof of their building, they built a wireless mesh network using chicken wire. Now, let me posit that something has gone wrong with regulation, really wrong, if the best wireless solution for entrepreneurs in San Francisco is the same technology that is used by farmers in Kansas to keep wayward birds holed up in the coop. This experience informs my view that the wireless infrastructure piece of the equation often seems to be the forgotten soldier in the ongoing mobile broadband revolution. We don't talk about it much, but without vast networks of towers, rooftop antennas, microcells, picocells, distributed antenna systems, or DAS, and other types of physical infrastructure, Americans wouldn't be able to send emails, surf the web, or watch videos over their mobile devices. And as our use of tablets and smartphones proliferates, so too does the need to deploy more wireless infrastructure to accommodate more mobile data traffic. But, as my opening suggests, it's not easy to deploy wireless infrastructure in the United States. The federal government has erected some unnecessary obstacles. Federal regulations that were written only with 200-foot tall towers in mind just don't make sense when applied to recent innovations like small cells. State and local governments have slowed deployment as well. Every consumer wants fast, dependable wireless service in his or her neighborhood. But many aren't as enthusiastic about having nearby the physical infrastructure that makes that kind of service possible. This sort of not-in-my-backyard sentiment can lead municipalities to needlessly delay or even block the installation of wireless infrastructure. To remove these roadblocks, I proposed last fall a comprehensive set of reforms to expedite the deployment of wireless infrastructure. Specifically, I called for the Commission to, first, exempt DAS from our environmental processing requirements. Second, to update our historic preservation regulations to take account of DAS and small cells. Third, to declare that the shot clock adopted by the Commission in 2009 and affirmed by the Supreme Court this year applies to DAS. Fourth, make clear that local moratoria on the approval of new wireless infrastructure that evades the Commission's shot clock violates Section 332C7 of the Communications Act. And finally, fifth, provide that if a local government does not act on a wireless facilities application by the end of our shot clock, that application will be deemed granted, as is the case right now in the video franchising context. So I am very excited that less than 1 year later, the Commission is seeking comment on all of these ideas in today's Notice of Proposed Rulemaking, and I'm thrilled to support it. I'm also pleased that we are soliciting feedback on other worthwhile proposals to implement Section 6409A of the Spectrum Act and to permanently exempt temporary towers from pre-construction environmental notification requirements. I am particularly happy that we seek comment on whether to adopt a deemed granted remedy for violations of both Section 6409A and Section 332C7 of the Communications Act. Right now, if a city does not process an application by the end of the FCC's shot clock, an applicant's only remedy is to file a lawsuit. In other words, the solution to municipal delay is litigation, a word that is often synonymous with delay. In one salient case, for example, Sprint was forced to battle for 7 years in federal and state courts as it attempted to build just 2 towers in Los Angeles County. If a local government does not act on a wireless facilities application by the end of the shot clock, I believe that application should be deemed granted. This would maximize the incentive for local governments to rule on applications promptly. It would allow companies to stop litigating over infrastructure and start building it. And it would ultimately promote an investment and job creation in this dynamic sector of the communications industry. On to all of the issues that are teed up in today's NPRM, it is critical that we move forward with alacrity. Indeed, we should bring the same urgency to the task that animates our push to make available additional spectrum for mobile broadband. For if our efforts on wireless infrastructure falter, much of our work on spectrum will be for naught. After all, even an unlimited supply of spectrum won't mean much without the infrastructure to carry wireless traffic to its destination. I want to thank Chairwoman CLYBURN for her leadership on this item and the terrific staff of the Wireless Telecommunications Bureau for all of their hard work. Chief Ruth Milkman, Jeff Steinberg, Peter Trachtenberg, Michael Smith, Juan Kim, Mania Baghdadi, Joyce Jones, Ivy Harris, Donald Johnson, Saurabh Chabra, Stephen Del Sordo, Weiren Wang, Jane Jackson, Maria Kirby, and Jessica Almond. The success of all of your efforts is evident to us today, and I believe it will be evident to consumers in the years to come when they enjoy better, more reliable, and more advanced wireless services. Thank you for your service.
Thank you, Commissioner. Our nation's demand for mobile broadband services continues to grow at an exponential rate. The ability of wireless providers to meet this demand depends not only on access to spectrum, but on the deployment of new mobile infrastructure. That is why the Commission has made it a priority to cut red tape that saps resources and slows broadband deployment. Today we seek comment on how we can change our processes to encourage greater deployment of new technologies such as small cells and distributed antenna systems. These innovative solutions multiply wireless capacity within existing spectrum resources and can be deployed relatively easily and inexpensively by consumers, enterprise users, and service providers. These newer technologies can be deployed on utility poles, street lamps, water towers, or rooftops, a big reason they are becoming more common. The time is ripe for the Commission to look at updating our rules for these new technologies. This item continues the review of our procedures, which apply to temporary towers. Often in demand with very little advance warning or for very short periods of time, temporary towers are used to restore communications during natural disasters or other emergencies and to provide additional capacity during events. Relaxing the rules that apply to these towers makes perfect sense. In this item, we propose a narrow exemption for the Commission's pre-construction environmental notification requirements for certain temporary towers. Under our proposed exemption, eligible towers must meet specified criteria. Specifically, they will be in use for 60 days or less, will be shorter than 200 feet in height, will involve minimal or no excavation, and will not require FAA marking or lighting. We are mindful of our statutory mandate to protect the nation's historic and environmental resources and have a special duty to protect Native American sacred sites and places of tribal cultural importance. The proposals in today's notice recognize that mandate. We also seek comment on rules to implement Section 6409A of the 2012 Spectrum Act. Under this section of the Act, a state or local government shall approve any request for a modification of an existing wire, tower, or base station that does not substantially change the physical dimensions of such tower or base station. Eligible facilities requests, including co-location applications and requests to replace existing equipment. Co-location, which involves placing wireless equipment on pre-existing structures, is often the most efficient means of expanding wireless coverage and capacity. Because most of the terms in the statute are undefined, however, we propose rules to clarify these terms and help all parties implement its requirements. Over the past 4 years, the Commission has taken a number of significant steps to reduce barriers to wireless infrastructure investment. We established a shot clock for processing wireless tower and antenna siting requests and ensure timely and rationally priced access to utility poles. Just this year, we established rules for signal boosters that will promote the deployment of such devices to expand wireless coverage. Today's notice is another step toward removing barriers to the deployment of much-needed wireless infrastructure. I, too, would like to commend the staff. Right now, the chief, Ruth MILKMAN, who I always try to rename, but she's still my friend, I think, Jane Jackson, Jeffrey Steinberg, Peter Trachtenberg, Michael Smith, Manya Baghdadi, Juan Kim, and others for providing us with such a thorough and thoughtful item on these critically important issues. I especially want to thank Peter for staying late last night to accommodate suggested edits to the notice of proposed rulemaking, and I could not leave the bench without thanking Louis Peretz and Michelle Ellison for their endurance also. So unless there is any more discussion, we will proceed to a vote. All those in favor say aye.
Aye.
Any opposed? The ayes have it, so ordered. The request for editorial privileges is granted. And Madam Secretary, if you would, please announce our next item.
Madam Chairwoman and Commissioners, the next item on your agenda will be presented by the Media Bureau. It is entitled Amendment of Section 73.355E of the Commission's Rules, National Television Multiple Ownership Rule.
Thank you, Madam Secretary. Good morning, Mr. Lake.
Good morning, Madam Chairwoman and Commissioners.
Whenever you're ready.
Thank you. We place before you a notice of proposed rulemaking that starts a proceeding to consider the elimination of the UHF discount in the application of the Commission's National Television Multiple Ownership Rule. Currently, that rule prohibits a single entity from owning television stations that, in the aggregate, reach more than 39% of the total TV households in the nation. In determining compliance with the 39% cap, the rule provides that television stations broadcasting in the UHF spectrum will be attributed with only 50% of the television households in their designated market areas. This is commonly referred to as the UHF discount. The discount was adopted in 1985 in recognition of the technical inferiority of UHF signals as compared with VHF signals in analog television broadcasting. But in light of the transition of full-power TV stations to digital broadcasting, completed in June 2009, there's a serious question whether this justification for the UHF discount continues to exist. Experience since the DTV transition suggests that UHF channels are no longer inferior to VHF channels. Joining me at the table are Hilary DeNigro, Chief of the Industry Analysis Division, Brendan Holland, Assistant Chief of that division, and Johanna Thomas, Attorney Advisor in that division. Johanna will present the notice.
Good morning, Madam Chairwoman and Commissioners. As Bill mentioned, the UHF discount was adopted in 1985 as part of the national audience restriction enacted at that time. Recognizing the inherent physical limitations of the UHF band, the Commission concluded that the technical limitations of UHF stations should be reflected in the implementation of the national audience cap. However, the Commission has long acknowledged that the basis for the discount is brought into question by the digital television transition. As early as the 1998 biannual review order, the Commission indicated that the UHF discount would not likely be necessary after the anticipated transition to digital television and stated that an NPRM would be issued to propose phasing out the discount once the digital transition was complete. In the 2002 biannual review order, the Commission again acknowledged that the digital television transition would eliminate the technical basis for the UHF discount and indicated it would review the status of the UHF discount in a subsequent biannual review. Following the 2002 biannual review order, however, Congress passed the 2004 Consolidated Appropriations Act, which among other things directed the Commission to modify its ownership rules to revise the national audience reach cap from 35% to 39%. The bill also amended Section 202H of the 1996 Act by requiring a quadrennial review of the Commission's broadcast ownership rules, rather than a biannual review, and specifically excluded the Commission from reviewing the National Television Ownership Rule in its quadrennial review. Various parties appealed the 2002 biannual review order, and the Third Circuit issued its ruling a few months following the passage of the 2004 Consolidated Appropriations Act. With respect to the UHF discount, the Third Circuit determined that the Commission has the authority to consider altering the UHF discount outside the context of Section 202H. In the 2006 Quadrennial Review Order, the Commission concluded that the discount was insulated from review under Section 202H, but announced that it would address the petitions, comments, and replies it had received with respect to the UHF discount in a separate proceeding. As expected, the experience with the digital television broadcasting has indicated that the inferiority of UHF channels is a thing of the past. The DTV transition has proved more challenging for VHF channels than UHF channels because digital television signals on the VHF spectrum have proven to be subject to greater interference. The tentative conclusions and proposals in the notice are as follows. The notice tentatively concludes that the Commission has the authority to modify the National Television Ownership Rule, including the authority to revise or eliminate the UHF discount. Specifically, it tentatively reaffirms that the 2004 Consolidated Appropriations Act does not preclude the Commission from revisiting the National Television Ownership Rule or the UHF discount in a proceeding separate from the quadrennial reviews of the broadcast ownership rules pursuant to Section 202H. The notice tentatively concludes that the historical justification for the UHF discount no longer exists, and the rule is therefore obsolete. It accordingly proposes that the UHF discount be eliminated from the National Television Ownership Rule. The notice proposes, in the event that the UHF discount is eliminated, to grandfather broadcast station ownership groups to the extent that they exceed the 39% national audience cap solely as a result of the termination of the UHF discount rule as of the date of release of the notice. The notice also proposes to grandfather proposed station combinations for which an application is pending with the Commission, or for those transactions that have received Commission approval but are not yet consummated, where those combinations would exceed the 39% cap as a result of the elimination of the UHF discount. Further, the notice proposes that any grandfathered ownership combination subsequently sold or transferred would be required to comply with the national ownership cap in existence at the time of transfer. The notice seeks comment on these proposals. Finally, given the challenges that VHF stations face in delivering digital television signals, the notice seeks comment on whether it would be appropriate at this time to adopt a VHF discount. The Bureau recommends adoption of the notice and requests editorial privileges.
Thank you, Ms. Thomas. Now we'll hear comments from the bench. Commissioner ROSENWORCEL.
The mechanics of this rulemaking may seem complex, but the underlying purpose is simple. Time advances, technology changes, and this agency must update its policies and rules. Remember 1985? In 1985, broadband was a pipe dream. Dial-up meant making a call on a phone, probably a hefty thing that was attached to the wall. Wireless handsets were the stuff of science fiction, and computing power on your desk probably involved a Commodore. A Walkman with a tape cassette was the portable way to listen to your tunes. On television, we watched Dallas Dynasty and Miami Vice. By any measure, it was a long time ago. Also in 1985, the Commission first put its ultra-high frequency, or UHF, discount for television in place. It was a product of the analog world. At the time, it compensated for the technical shortcomings of UHF signals used by television stations allocated to channels above 13. In the analog era, UHF stations had weaker propagation, limiting audience size. Their signals simply did not travel as far as very high frequency or VHF band signals allocated to channels 13 and below. As a result, it was the low VHF stations that were the most desirable because their signals reached the most viewers. To reflect the more limited scope of UHF signals and their less desirable status in the marketplace, they counted only half as much for the purposes of our television ownership rules. By all accounts, this was a fair approach to analog technology. However, as we just heard, all of our full-power television stations have now converted to digital technology. The analog era is over. This is the digital age. With respect to UHF and VHF signals, this means the world is now upside down. The very UHF signals that had the least reach in analog broadcasting now have the furthest reach in digital broadcasting. Conversely, the once desirable VHF signals now have the weakest reach in digital broadcasting. We should here, as elsewhere, update our policies to reflect current technologies. Our rules should not be grounded in technical constraints that no longer exist. That is what this rulemaking is all about. Still, as we proceed, we must be practical about the impact on the marketplace today. That is important. I look forward to the record that develops, and I want to thank the Media Bureau for their hard work.
Thank you. Commissioner Pai?
Thank you, Madam Chairwoman. The FCC issued a national television multiple ownership rule in 1985. At the time, it prohibited a single entity from owning television stations that collectively reached more than 25% of the national television audience. And it recognized the, quote, inherent physical limitations, unquote, of analog television signals in the UHF band as compared to VHF signals. Because these limitations placed licensees of UHF stations at a competitive disadvantage vis-a-vis VHF licensees, the FCC determined that UHF stations should be attributed with only 50% of the television households in their designated market areas for purposes of calculating nationwide audience reach. And for the last 28 years, this UHF discount has been an integral component of the Commission's National Television Ownership Rule. However, our nation's transition from analog to digital television has eroded the basis of the UHF discount. The Commission recognized more than a decade ago the DTV transition likely would eliminate the physical characteristics that made UHF spectrum less desirable than VHF spectrum for television broadcasting. And as today's item indicates, the DTV transition has borne out the Commission's expectation. Indeed, it now appears that UHF spectrum is more compatible with digital television signals than VHF spectrum, as Ms. Thomas's presentation observes. And as the Commission has previously stated, the disparity between UHF and VHF channels has, if anything, been reversed. For these reasons, I agree with my colleagues that the time probably has come for the UHF discount to take its place in the history books, alongside the fairness doctrine, the Morse code exam requirement, there really was one once, and other outdated regulations. Nevertheless, I am dissenting from this morning's notice of proposed rulemaking for two reasons. One relates to the national audience cap. The other relates to the grandfathering of transactions. Let's take the first point first. First, I do not believe that we can modify the UHF discount without simultaneously reviewing the national audience cap, which currently stands at 39%. The NPRM recognizes the interdependent relationship between the national audience cap and the UHF discount. It acknowledges that, and I quote, elimination of the UHF discount would impact the calculation of nationwide audience reach for broadcast station groups with UHF stations, unquote. Or, to put the matter succinctly, eliminating the UHF discount would substantially tighten the national ownership limit. For example, one company that is now more than 19 percentage points under the cap would be only 3 points below the cap if the UHF discount were eliminated. But while today's item proposes to tighten the national cap, it does not see comment on whether doing so would be a good idea. The NPRM, in my view, therefore misses the forest, the overall national cap, for the trees, or rather a single tree, the UHF discount. To be sure, one could argue that Congress took away our authority to change the cap in 2004, when it instructed us to increase the national cap to 39%. But today's NPRM rightly rejects that position and expressly states that the Commission has the authority to, quote, both modify the national audience reach restriction and UHF discount, unquote. Consistent with that view, because we are proposing to end the UHF discount, I believe we should ask whether it is time to raise the 39% cap. Indeed, this step is long overdue, notwithstanding any change to the UHF discount. The Commission has not formally addressed the appropriate level of the national audience cap since its 2002 biennial review order, and it has been nearly a decade since the 39% cap was established. Needless to say, the media landscape has changed dramatically in the many years since. I've spoken a lot about the importance of reviewing our rules to keep pace with changes in technology and changes in the marketplace, and I wish today's item had done so with respect to this particular issue in a comprehensive manner. I also wish that today's item sought comment about the impact of this proposal on diversity. Given that companies such as Univision benefit from the UHF discount, I am disappointed that the NPRM does not explore this important issue. I nonetheless encourage commenters to address it. Second, I have concerns about how the NPRM addresses grandfathering. I am certainly pleased that the item at least proposes to grandfather existing combinations that would exceed the 39% cap if the UHF discount were eliminated, as well as combinations that would exceed such a cap because of an application that is currently pending at the Commission. But this does not go far enough. In my view, any combination that is in existence or pending with the Commission as of the date the UHF discount rule is eliminated should be grandfathered. And the reason is pretty simple. Remember what today's item does. It only proposes to eliminate the UHF discount. It does not actually eliminate the UHF discount. The UHF discount will be the law of the land tomorrow and every day after that, unless and until the Commission formally votes to repeal it. Through its grandfathering proposal, however, today's NPRM effectively tells the private marketplace to behave as if the UHF discount has already been eliminated. This would render the rest of the rulemaking process a formality. The practical results of this sentence first, verdict afterwards approach will be to dampen the market for broadcast transactions and to depress station values. That won't serve either private or public interests very well. In conclusion, I was willing to compromise and support today's item if either of my two major concerns with respect to the national cap or grandfathering were addressed. But because the NPRM we adopt this morning proposes to dramatically tighten our national television ownership cap and to essentially make that rule change effective immediately, I must respectfully dissent. Thank you, Madam Chairwoman.
Thank you. I am pleased today to issue a notice of proposed rulemaking that initiates a proceeding to consider the elimination of the UHF discount. The Commission adopted the UHF discount, as you heard, nearly 30 years ago, when UHF signals were considered to be technically inferior to VHF signals in analog television broadcasting. The rule was a means to address the competitive disadvantage experienced by UHF stations at the time. Yet with the transition of full power stations to digital broadcasting completed in 2009, the technical inferiority of UHF channels for the transmission of digital television signals appears to be a thing of the past. Thus, the technical justification for the UHF discount no longer appears valid. The Commission and the television industry have anticipated the elimination of this discount for well over a decade. It is our task as regulators to ensure that our rules reflect current market realities. While it may also be appropriate to undertake the significant task of re-examining the national cap at some point in the future, we cannot in the meantime ignore the impact the DTV transition has had in the marketplace, changes that everyone must acknowledge currently stand this rule on its head. The question we ask today are ones the Commission promised to raise many times in written orders and should not surprise any market participant. The notice specifically reflects the Commission's intent to fairly consider and accommodate as appropriate existing television station combinations, pending applications, and any future transactions that present special circumstances. The common sense action outlined in this NPRM should help to ensure that our rules reflect the current technical realities of television broadcasting. It is also consistent with the President's direction in his executive order to review significant regulations and determine whether they still serve the public interest. I wish to thank Bill Lake and the staff of the Media Bureau, particularly Ms. Johanna Thomas, Ms. Hillary DeNegro, and Mr. Brendan Holland for their hard work on this item. And of course, I wish to thank Bill Lake and the rest of the staff for their hard work on this notice. And I would also at this time like to thank the general person to your right, Mr. Lake, Mr. Sean Liv, who worked overtime without additional pay. I saw to that. For this item, as well as every other item on today's agenda. So thank you very much. So unless there's any more discussion, we will proceed to a vote. All those in favor say aye.
Aye.
All those opposed say nay.
Nay.
The ayes have it. So ordered. The request for additional editorial privileges is granted. Madam Secretary, if you would, please announce our next item.
Madam Chairwoman and Commissioners, the third item on your agenda today is entitled Improving the Resiliency of Mobile Wireless Communications Networks, to be presented by the Public Safety and Homeland Security Bureau.
Thank you, Madam Secretary. Good morning, Mr. Turetsky.
Good morning.
Whenever you're ready.
Good morning. My name is David Turetsky, and I'm Chief of the Public Safety and Homeland Security Bureau. With me today are David Firth, Deputy Chief of the Bureau, and Brian Hurley, an Attorney Advisor in the Bureau. Today we are presenting to the Commission a notice of proposed rulemaking to facilitate improvements to the resiliency of mobile wireless networks. This builds on prior Commission inquiries and rulemakings and suggestions presented to the Commission at the Sandy Field hearings earlier this year. Promoting the reliability and resiliency of our nation's communications infrastructure is among the Commission's most important public safety objectives. Increasingly, it is mobile wireless infrastructure that Americans rely on for their most critical communications. Recent studies reveal that about 38% of American households have cut the cord and rely exclusively on mobile phones, and in the state of California, 75% of 911 calls originate on wireless networks. These figures underscore the importance of ensuring the resiliency of our nation's mobile wireless networks so that when a disaster strikes, the most critical communications are still able to get through. Last fall, Superstorm Sandy devastated the eastern seaboard, disrupting mobile wireless communications for millions of customers. About 25% of cell sites in the storm's path were knocked out, and in some counties that figure was more than twice as high. Yet these impacts were not spread evenly among providers. As was the case during prior storms, some wireless providers withstood Superstorm Sandy better than did others in the very same counties. Moreover, from what the Commission has learned so far, it appears that the measures that providers undertake to harden their networks against disaster conditions may account for much of this disparity. In particular, some providers are much more likely than others to equip sites with dedicated emergency backup power. In this notice of proposed rulemaking, we seek comment on proposals to provide consumers with more transparent information about how mobile wireless networks perform during major disasters and ultimately to improve the resiliency of these networks. I would like to briefly thank for their valuable input the many staff members across the Commission's bureaus and offices that worked on this item, and in particular the Commission's Chief Technology Officer, Henning Schultz-Rinne, and Chief Economist Steve Wildman and his staff, and the General Counsel Sean Lev and his staff. I'd also like to thank, in addition to David and Brian, the other members of the Public Safety Bureau team for their hard work completing this notice, particularly Renee Rowland and John Healy, Lauren Kravitz, Jeff Goldthorpe, and Lisa Folks. With that, I turn things over to Brian Hurley, who will now present the item.
Good morning. Good morning. Today we present for the Commission's consideration a notice of proposed rulemaking that seeks comment on proposals to improve the resiliency and service transparency of mobile wireless networks. This includes a proposal to require commercial mobile radio service, or CMRS providers, to report daily to the Commission during major disasters the percentage of their cell sites that are operational in each affected county. The Commission would then disclose this information on its website. These percentages can be derived from information that many providers already report during disasters via the Commission's Voluntary Disaster Information Reporting System, or DIRS. We seek comment on whether public disclosure of such percentages could provide consumers with a useful, high-level snapshot of how well mobile wireless networks withstand and recover from disasters, which they could use as a yardstick to compare providers. We also seek comment on whether, by making providers publicly accountable for their performance, such disclosures could incentivize providers to improve the resiliency of their networks, while granting them flexibility over how to implement such improvements. The notice seeks detailed comment on all aspects of this proposal. It invites comment on the parameters of the proposed reporting and disclosures, including on their scope, their timing and frequency, and their relationship with DIRS. The notice also asks whether there are other measures the Commission should consider, including alternative forms of informational disclosure, performance standards, or voluntary initiatives of some kind. The Bureau recommends adoption of this item and requests editorial privileges.
Thank you, Mr. Hurley. Commissioner ROSENWORCEL?
Thank you. As we all know, last year, Hurricane Sandy ripped apart the East Coast. Our city saw floods, coastal areas saw fires, and some communities were even waylaid with snow. Power outages were widespread. Across the affected areas, 1/4 of our wireless towers failed. At the moment when so many of us needed to reach out, one of our major means of communications did not work. Earlier this month, rain pounded on the parched ground in Colorado. By the time it stopped, hundreds of road miles were washed out. Entire towns resembled lakes. At one point, 12,000 people were not accounted for, lost to family and friends. Local officials cited wireless network outages as a significant hurdle as they sought to locate survivors. Just last week in New Jersey, a fiber optic cable cut disrupted wireless service in towns near the shore. Homeowners without traditional landlines found themselves unable to make calls, conduct business, and reach out to neighbors. In all of these events, we are grateful that carriers sought to fix what failed and get service up and running as soon as possible. But in disasters, days, minutes, and seconds count. While we can never make networks fail-proof, we should take smart steps to make sure that they are resilient. The object lessons from Hurricane Sandy, Colorado, and New Jersey that I just recounted are unlikely to be the only episodes where essential communications get cut in crisis. But I think we've had enough examples to know that we need an honest conversation about network resiliency in the digital age. As more consumers migrate from traditional landline services to new wireless and IP services, they benefit from all the new functionalities they provide. But unlike the landline phones plugged into the wall, these new services are dependent on commercial power. This means two things. First, we must ask hard questions about backup power and how to make sure our new networks are more dependable when we need them most. Second, we need to make sure that consumers understand not just the benefits, but also the limitations of new technologies when they reach out for assistance. Preparing for the unthinkable with extra batteries and solar-powered chargers when the plugs in the wall do not work is not just prudent, it is now necessary. While today's rulemaking does not proceed neatly on these lines, I believe it is essential to continue the conversation, because making sure our networks work in disaster and can withstand Mother Nature's wrath will make us all stronger and make us more safe. Thank you.
Thank you, Commissioner. Commissioner Pye?
Thank you, Madam Chairwoman. I want to start by thanking the staff of the Public Safety and Homeland Security Bureau, Chief David Turetsky, my friend dating back to the 20th century, David Firth, and Brian Hurley for that presentation. Americans want wireless services that work. And with 4 or more wireless providers competing throughout the country, it's no wonder that wireless carriers are rushing to expand and upgrade their networks to meet that demand. Perhaps that's why they've invested $30.1 billion last year alone to improve their networks. Perhaps that's why they've deployed 301,779 cell sites throughout the United States. Perhaps that's why they're exploring heterogeneous networks, using small cells, distributed antenna systems, and macro cells with overlapping coverage, not to mention voluntary roaming agreements and Wi-Fi offload. They've done all these things to provide consumers the best network experience possible, given the limited spectrum available for mobile broadband. And to its credit, the Commission appreciates these facts. But despite acknowledging these realities, the Commission nevertheless insists today on proposing reporting requirements that I believe would confuse and mislead consumers. Most consumers are bound to think that if the FCC requires wireless providers to report the percentage of out-of-service cell sites within a county during certain natural disasters, that information says something about a network's reliability or resiliency. But it simply may not. Just as Robert Griffin III's 63.3% completion rate doesn't tell you anything about the Washington Redskins' overall performance this year, there's no particular correlation between the percentage of interoperable cell sites and the coverage and capacity maintained by a provider during a disaster. For example, one macro cell going down can impair coverage far more than 10 small cells that go out of service. So holding up percentages as a measure of reliability or resiliency is bound to mislead consumers into thinking that one provider is better than another, even if in reality the opposite is true. And not all emergencies are natural disasters. In fact, most of them are not. Thus, highlighting the performance of providers in select counties during only a few disasters each year sheds little light on the day-to-day reliability that ultimately may be more important for saving lives. In short, I am disappointed that the Commission was not willing to first figure out what additional information about network reliability, if any, consumers actually want and need to make informed decisions before proposing this mandate. I also have serious doubts about much of the analysis in the Notice of Proposed Rulemaking, especially in those sections addressing the costs and benefits of the proposal and the Commission's legal authority. For these reasons, I respectfully dissent. Thank you, Madam Chairman.
Thank you. When disaster strikes, Americans increasingly rely on their mobile phones to call 911 and to check on the well-being of those they care about. But all too often, wireless network outages in the wake of disasters leave many Americans disconnected at precisely the time they have the greatest need to communicate. At the peak of Superstorm Sandy, approximately 25%, as you have heard, of the cell sites in the affected region were disabled, and more than double that figure were disabled in the hardest hit counties in New York and New Jersey. Without question, communications providers worked tirelessly in their storm-ravaged areas to restore service. While some disaster-related disruptions may be inevitable, we must and can do more to prepare for future emergencies. So the question remains, what can we do to prevent such extensive wireless outages from occurring in the first place? Earlier this year, the Commission held field hearings to explore ways we can promote the resiliency and reliability of communications networks during disasters. We learned during Superstorm Sandy and other recent disasters that the level of cell site outages varied among wireless providers even within the same geographic area. In addition, we found that choices and practices regarding network resiliency vary among wireless service providers. Taken together, these differences suggest that some approaches are more effective than others and that there are additional actions providers can take to improve the ability of their networks to withstand disasters and reduce service disruptions to consumers. The primary proposal in the Notice of Proposed Rulemaking does not dictate what methods wireless providers should use to harden their networks. Those decisions are best left to industry. But what would create greater transparency is information on carrier performance that up to now has not been publicly available. This would empower the public to hold wireless providers accountable for the results of those decisions. Specifically, we are proposing that wireless providers submit to the Commission for public disclosure on a daily basis and immediately after major disasters, the percentage of cell sites within their networks that are operational. Providers would report this information on a per-county basis for the designated disaster areas. Since this data can be derived from information that providers already submit daily to the Commission on a voluntary and presumptively confidential basis during disasters, our proposal should not impose any significant new burden on wireless providers. But our proposal could have a significant impact in other ways, making cell site outage information public, empowering consumers, and creating competitive incentives for wireless providers to improve network resiliency during emergencies. We seek input from all stakeholders on this proposal and many related questions. This item builds on the Commission's existing work to improve the reliability and resiliency of the wireless communications network that serve 911 call centers during disasters. Today, we focus on improving the reliability and resiliency of wireless networks that are used to call 911 in the first place. We cannot, again, prevent disasters from happening, but we are hopeful that these actions can help Americans keep Americans safer when emergencies do occur. I, too, would like to thank Chief TURETSKY and his talented staff for crafting a thorough and well-written notice for proposed rulemaking, and as well, again, I would like to thank Louis Peretz and Michelle Ellison for their coordination on this item. And unless there are if there's any more discussion, we will proceed to a vote. All those in favor say aye.
Aye.
All those opposed say nay.
Nay.
The ayes have it, so ordered. The request for editorial privileges is granted. Madam Secretary, if you would, please announce our next item. Thank you very much.
Madam Chairwoman and Commissioners, for your final presentation today, the Media Bureau will present the latest update on progress towards the upcoming October 15th through October 29th open filing window for applicants seeking to operate new low-power FM radio stations.
Welcome back, Mr. Lay.
Thank you. Good morning again, Madam Chairwoman and Commissioners. I'm very pleased to have this opportunity to share with you the details of what the Media Bureau's audio division has been doing this year to prepare for the much-awaited low-power FM window, which will open in just a few weeks. With me at the table are Peter Doyle, Chief of the Audio Division, Jim Bradshaw, Chief Engineer in that division, and Parul Desai, Attorney Advisor in that division. Jim will describe our efforts to reduce the backlog of long-pending FM translator auction participants. Parul will give you details about the outreach efforts in the division to prepare for the LPFM window. Jim.
Thanks, Bill. Good morning, Madam Chairwoman and Commissioners. The Commission established the low-power FM service to promote localism and viewpoint diversity, to create opportunities for new voices on the airwaves, and to provide programming responsive to local community needs and interests. Many believe that community radio was the best way to counter increased consolidation and homogeneous programming in the mature radio industry. Competing for the same spectrum is the FM translator service, which rebroadcasts full-power FM stations. In 2003, over 13,000 FM translator applications were filed in the Auction 83 translator window. In 2005, in response to concerns from low-power FM advocates that the continued licensing of these Auction 83 filings could preclude additional LPFM license, the Commission announced a 6-month freeze on further translator application processing. Despite several attempts to move forward, the status quo remained. In part, this delay reflected the enormous stakes at issue. On January 4, 2011, President Obama signed into law the Local Community Radio Act, or LCRA. Enactment of the LCRA set in motion a series of implementing rulemaking proceedings. The Commission's clear goal during this period has been to implement a deceptively simple goal to ensure that licenses are available for both new translator and LPFM stations. Relying heavily on millions of engineering calculations to determine spectrum availability in over 150 markets, the Commission substantially finalized rules for the licensing of the remaining 6,350 translator applications and for LPFM applications filed in the next window in a December 2012 order. The first step has been to resume the processing of the original Auction 83 filings. As the Commission noted in the last order, it is critical for the Media Bureau to complete substantially all of its processing of the pending FM translator applications prior to the opening of the LPFM window. The Bureau has taken this directive very seriously, and I'm happy to report on the substantial progress that has taken place since then. We have published 12 public notices and opened 7 windows relating to the processing of the remaining translator text box applications. I want to recognize the dedicated staff in the audio division who committed much of their year to this effort. First and foremost, I must mention the core translator engineering team. This team consists of 2 of the most dedicated and hardworking engineers in the building, Rob Gates and Larry Hanif Ali. The 2 of them have moved mountains of paperwork and e-paperwork this year, reviewing literally thousands of various filings over the past 9 months. The direct results of their efforts will be the authorization of 1,700 new FM translator construction permits during 2013. The critical task in these efforts has been the implementing of the LCRA mandated protection scheme that sought to promote 2 clashing goals: preserving identified LPFM licensing opportunities while facilitating the authorization of as many Auction 83 translator proposals as possible. This often required multiple reviews of so-called preclusion showings of individual applications, as translator applicants availed themselves of numerous opportunities for amendments and settlements to avoid conflicts with protected LPFM channel point combinations. This team developed new computer tools and procedures to meet this challenge and did so with limited resources and under enormous time constraints. It has been a group effort to get through this work in relatively short order, and I would like to personally thank everyone in the division who has been involved. Now, let me share some of the details of what the team has done this year. It all started with a national and market-specific cap implementation process. We opened a 2-week window in January to permit applicants to come into compliance with these caps. Then we moved to process identified singleton applications at locations with ample opportunities for LPFM licensing. 631 long-form applications were filed and quickly processed. Only 67 of those applications remain pending, with a vast majority awaiting international approvals. Then, in response to a March 14th Bureau public notice, translator applicants submitted over 470 filings to show their proposal would not preclude LPFM licensing opportunities in spectrum-limited markets. On May 21, 2013, the Bureau released a public notice announcing the mutually exclusive status of 1,468 FM translator applications in 539 groups. This PN provided a 2-month settlement opportunity. By the filing deadline of July 22nd, we received dozens of settlement agreements and dismissal requests and over 600 amendments. As a result of the various settlements, amendments, and dismissals, fewer than 250 of those applications remain in mutually exclusive groups. Following the close of the settlement window, we issued public notices in July and September that invited the filing of over 1,340 additional long-form applications, a total that does not include the more than 700 singleton applications identified in the February singleton public notice. I'm quite sure that this is much more than you ever wanted to know about FM translator processing, so let me boil this down to a single snapshot. Of the 6,350 Auction 83 applications that were on file in December 2012, only 8 have not either been dismissed, provided the opportunity to submit a long-form application, or given the opportunity to submit a settlement agreement. Our efforts could result in the authorization of 1,700 new FM translator construction permits during calendar 2013. This would represent a 30% increase in the number of authorized translators in the U.S. We look forward to completing the grant process for the remaining translator construction permits so we can focus our efforts on the coming LPFM window. Now I will hand it over to Parl to provide an update on the Bureau's outreach efforts in preparation for the LPFM window.
Thank you, Jim. Good morning, Madam Chairwoman, Commissioner ROSENWORCEL, and Commissioner Pai. My name is Parl Desai, and I'm an attorney advisor in the Audio Division and have been extensively involved in the Division's recent LPFM licensing and policy initiatives. Last December, the Commission set an ambitious target date of October 15, 2013 for the opening of the second national LPFM window, the first LPFM window in over a decade. I am pleased to report today that the Media Bureau is poised to hit that target in the bullseye. As Jim and his translator team took on the task of processing the pending 6,000-plus translator applications, the audio division has also been working diligently and creatively on the LPFM licensing track. We have made numerous changes to the LPFM New Station application form, Form 318, and form instructions to implement the eligibility, selection criteria, and technical acceptability changes adopted in the LPFM rulemaking proceeding. The Local Community Radio Act and the ensuing rule changes have vastly expanded LPFM licensing opportunities. As a result of these statutory and rule changes and the dismissal this year of approximately 4,000 Auction 83 proposals, the upcoming window will be the first genuine opportunity for widespread licensing of LPFM stations in urban areas. Illustrative examples of this change in licensing opportunities is shown in this slide, which compares the number of licensed stations in selected markets and the number of identified available FM frequencies in merely the core areas of these markets. LPFM advocates have repeatedly emphasized the importance of providing ample time for local nonprofits to plan and file. In response, the Media Bureau issued a public notice in June confirming the Commission's target date for the window and establishing a closing date of October 29, 2013. At the same time, we opened the electronic door in CDBS to permit applicants to begin completing and validating their applications immediately. At this point, hundreds of applicants have taken advantage of this opportunity to start the LPFM New Station application process. In conjunction with the release of the June LPFM window public notice, we initiated a series of outreach efforts to assess potential LPFM applicants. These efforts are aimed at ensuring that applicants are well informed and have access to the information and tools necessary to make the application process as simple, seamless, and error-free as possible. We have updated and expanded our LPFM webpage. We have also created a FAQ page and 2 blogs on the fcc.gov website. We have promoted these new features by distributing them through our Facebook and Twitter accounts. The first blog provides general information about the LPFM service and application process, while the second blog focuses on some common themes and questions we have identified in the numerous calls and emails directed to the audio division staff. On August 20th, we conducted a highly viewed webinar, which is now archived on the FCC's website and available on the FCC's YouTube page. This first webinar explained the step-by-step process of creating a CDBS account, which is required to electronically file an application. The webinar also explained how to use the LPFM channel finder tool, which assists applicants in determining whether there is an available FM channel in the applicant's local community. Additionally, the webinar reviewed all Form 318 questions and discussed the information necessary and which must be included in the application filing. We answered dozens of legal and technical questions during the webinar. Our second webinar, scheduled for October 3rd at 1 p.m., will chiefly be a question and answer session with audio division staff giving applicants an open forum to ask questions and raise concerns. Finally, the staff recognizes that potential applicants run the full gamut from very sophisticated to very unsophisticated. We have attempted to make ourselves easily accessible and responsive to all. We have dedicated specific staff to respond to telephone inquiries at 202-418-2700, established a dedicated LPFM email address, lpfm@fcc.gov, and Twitter account, #LPFM questions, to ensure that applicants receive complete and timely answers to their questions. Our goals for after the window closes are no less ambitious. We anticipate that we will begin to immediately identify and provide public notice of acceptable singleton proposals. Our plan is to begin granting such applications as early as January 2014. We are committed to issuing the first of what is likely to be a series of public notices that identify mutually exclusive groups of acceptable applications within several months of the close of the window. These notices will provide opportunities for applicants within these groups to make technical amendments and pursue settlements to resolve conflicts. Audio division staff has gained a great deal of experience and expertise in processing the thousands of NCE New Station applications from 2007 and 2010. We are confident that we can apply lessons learned to these similar LPFM point system omnibus orders. The Commission's expeditious implementation of the Local Community Radio Act of 2011 has made it possible to open the next LPFM window in just a few weeks. We are appreciative of the many groups such as Prometheus Radio Project, Common Frequency, Rec Networks, and Color of Change that have also been assisting applicants. As a result of all our collective efforts, we are looking forward to witnessing the growth of a robust and sustainable community radio service over the next few years.
Thank you. Thank you, Mr. Bradshaw and Mr. Sy. At this time, I will entertain comments from the bench. Commissioner Rosenworcel.
Thank you. There is something special about a voice in the air, one that rises above the din and provides local radio with unique local character. That is why, in these days of exploding global online content, there is still great value and art in community broadcasting. Now, courtesy of the Local Community Radio Act, this commission is poised to multiply the number of local voices on radio in communities across the country. This means new opportunities for nonprofit associations, schools, religious organizations, and public safety groups to broadcast to their communities and gain a footing in the radio business. This could lead to hundreds and maybe even thousands of new low-power FM stations up and down the dial. This is exciting. The road to this day, though, was a long one, because more than a decade ago, in 2000, the Commission first authorized the creation of low-power FM stations to provide non-commercial, educational, and local groups with the opportunity to provide a community-based radio service. The same year, Congress passed legislation delaying the removal of third adjacent channel separation requirements, while also requiring the Commission to study interference issues and report its findings. While third adjacent channel separation requirements sounds technical and small, it has had big impact, limiting the Commission's ability to issue licenses for community broadcasting, especially in urban areas. But in 2010, the Local Community Radio Act, which removed these separation requirements, was signed into law. Since that time, as we have just heard, the Commission has been busy. We have readied our processes, managed an earlier influx of translator applications, and balanced the need to protect full-power stations while providing opportunities for low-power applicants. The Media Bureau deserves tremendous credit for its thoughtful work on low-power FM to date. Now, however, is showtime. We open the window for new filings for low-power FM stations just a few days from today. So I hope our applicants show us in force how low-power FM can become a more vibrant part of community broadcasting, a source of new content, a driver of new music, a platform for unique local news. We can add real diversity to the FM dial. We can make that voice that rises in the air even more local and more interesting. I, for one, can't wait. Thank you.
Thank you. Commissioner Pai?
Thank you, Madam Chairwoman. Last December, when we adopted the sixth report and order, I asked my colleagues to set October 15th, 2013 as the target date for opening the next low-power FM, or LPFM, filing window. And I was pleased when that suggestion was incorporated into the item. Now, I know at the time there were some out in the hinterland who weren't sure that the Commission would be able to meet that October 15th target date. But those skeptics underestimated the staff of the Media Bureau's audio division. Over the past 9 months, the audio division has done yeoman's work. And thanks to their efforts, the Commission stands poised to open the LPFM filing window in just 3 weeks. I know that it wasn't easy. In addition to preparing for the filing window, as we've heard, the audio division has processed literally thousands of FM translator applications. Rob Gates and Larry Hanif Ali in particular deserve our thanks and, frankly, my awe at that accomplishment. And that wasn't all that was on the division's plate, of course. The audio division has also been developing a comprehensive notice of proposed rulemaking circulated just last week on revitalizing AM radio, a cause that is personal, some might say quixotic even, to some on the 8th floor. I want to thank Peter Doyle, Jim Bradshaw, and Parul Desai for that presentation. I also want to personally thank Peter and Jim for the endless stream of emails you get from a problematic commissioner every now and then. You would be well within your rights to put me in your spam filter, and I'm glad that you have not done so thus far. but I am holding my breath. Because of their efforts, I'm optimistic that we will have a successful LPFM filing window that will enhance diversity and localism on the FM band. I encourage community organizations across the country to take advantage of this opportunity, and I look forward to hearing the programming that all of them are going to produce in the years to come. Thank you, Madam Chairman.
Thank you, Commissioner. Are you extending that offer to your colleagues, too, in terms of the spam? Anyway, just asking. Jim and Peru, I am so thrilled. We are poised for a dramatic and historic explosion of diverse local voices on the radio band. I cannot wait. Once again, I wish to extend special thanks to Congressman Michael Dole and Congressman Lee Terry, as well as Senator Maria Cantwell and Senator John McCain, the sponsors of the Local Community Radio Act of 2011. Without their leadership, today's report and the nearing LPFM window would not be possible. It also has been rewarding to work with my colleagues over the past several years in implementing LCRA in a fair, thoughtful, and responsible way. I thank them for leading us toward this next LPFM window. In particular, I want to salute the efforts of former Commissioner Michael Copps, who was and remains a fierce champion for media localism, diversity, and competition. While we have done so much, we have so much more to do. We don't know today whether 1,000 or tens of thousands of applications will be filed in the October LPFM window, but we must be prepared either way. I thank the Media Bureau for its ongoing outreach efforts and its commitment to make this window a success. I thank them in advance for devoting their best efforts to scaling the mountain of licensing work that looms directly ahead. I am sure that the results of this work and this window will richly reward all of our efforts. As I have traveled this country, I've been overwhelmed with the stories of low-power FM supporters and those who are desperate to find a place on the radio dial. Farm workers, tribes, niche ethnic and language communities, community service organizations, they all see the LPFM service as a lifeline. We cannot wait any longer to respond to these needs, and I'm gratified that we are about to do so. In the course of this proceeding, we have learned much about the potential for expanding community radio in our nation. Radio is a mature service, and it does not come as a surprise to learn that no spectrum remains for LPFM stations in the core areas of a few of the country's largest cities. This is extremely regrettable because I know firsthand that the need for greater diversity of voices in these areas is huge. As a result, we must continue to look for ways to expand media opportunities for minority groups, underrepresented ethnic and niche language communities in particular, and I pledge to do so. Nevertheless, I am hopeful that our implementation of the LCRA and adoption of various service, selection, and eligibility rule changes will result in the licensing of many hundreds of stations deeply rooted in their communities. In this regard, I am most excited about two particular aspects of this window. The first, the rule changes designed to spur an increase in the origination of local programming content, the gold standard for broadcasting. The second is the impact of those technical changes that will make FM frequencies available for the first time to nonprofit groups in major metropolitan areas. I believe that the sustainability of LPFM service is directly tied to its ability to attract listeners in our urban centers. Prospects appear good. These stations will be able to achieve significant coverage of densely populated neighborhoods. Moreover, our great cities are teeming with extraordinary diversity. Most of these diverse groups, however, have no voice at all in the current media landscape. Providing an opportunity for ethnically and culturally diverse people to share their experiences and aspirations will enrich us all and strengthen our common bonds. Once again, let me say I cannot wait. Thank you to the Oracle, Peter Doyle, and your team in the audio division, including Deputy Chief Jim Bradshaw, Jordan Brin, Lisa Scallon, Michael Wagner, is that Wagner, and Mike's legal team, including Stephen Spab and Kim Varner. I also want to echo Jim's thanks to Rob Gates and Hanif Ali. I cannot imagine facing an inbox with over 6,300 applications in it. So Rob and Larry, your dedication is most inspiring. At this time, I don't know if there are any announcements my colleagues would like to make.
We have a few.
So thank you very much. Okay.
I want to welcome back to the office Marquita Boozer. She joins us again after her maternity leave and welcoming Mason Eli into the world. So I can say with confidence and from experience, she looks absolutely great. Mason is adorable, though I'm sure he has rocked her world because kids do that. But we are thrilled to have her back. Now, we also have some less happy news. Last month, Alec Hohn-Sarek decided to leave my office and the commission to pursue other opportunities. He's here today, so there are two things you need to know about working with Alex. First, he has a reliable stash of low-end candy.
I didn't know that.
Second, he has an equally reliable stash of high-end scotch. Both come in handy. But it is more than that endears us to Alex. He has been a trusted advisor in my office and an asset to the Commission on the many media and technology issues he worked on as policy director. He is a fountain of good advice, full of endless smarts, and great, maybe even legendary judgment. He has also had a storied career in public service. Before his stint here, he served as Deputy General Counsel at the Department of Commerce. Before that, as Senior Counsel on the Senate Commerce Committee with oversight of the Competitiveness, Innovation, and Export Subcommittee, as well as the Consumer Protection, Product Safety, and Insurance Subcommittee. He also served as counsel for Senator Barbara Boxer. And before that, he worked as an attorney at Latham & Watkins and Sullivan and Cromwell, and as a law clerk for the Honorable Benson Everett Legg of the United States District Court for the District of Maryland. That's a pretty powerful legacy, and as he leaves us here, I just wanted to thank him for being such a good colleague and an even better friend. So thank you, Alex. I also want to thank, among others, the chairwoman and our Media Bureau chief for allowing us to have Holly Sauer back in my office to come and fill the gap. She is well known in these halls. Her knowledge of media issues and this agency might be encyclopedic, and we'll put that to the test in the coming weeks. So we're really excited to have Holly back with us, too. Thanks.
Thank you. Commissioner Platt?
Thank you, Madam Chairwoman. I have a few staff announcements from our office, but before I make those, I would like to say a quick word about Alex. I informed him on his last day, and I actually handed him a piece of paper containing Commissioner Rosenworcel's statement announcing his departure, that I would be vigorously and forcefully dissenting from that announcement. I can only hope that a court will actively assert jurisdiction over that announcement and reverse his decision in the near term. But barring that, we certainly wish him well in his future endeavors, and we will miss him in our office, although we never got a chance to taste the scotch. I would like to take a couple of minutes to introduce our interns for the fall semester, Mike Byrne, Allison Nemeth, and Michael Williams. We will start with Mike Byrne. Mike grew up in Charlottesville, Virginia, and he earned his undergraduate degree in history and Latin American and Iberian studies from the University of Richmond. Que bueno. During his senior year in college, Mike wrote his thesis on the cultural and economic circumstances of the 1970s that gave rise to American auteur film. So what this really means is that Mike had an academic excuse to spend countless hours watching films by American directors like Stanley Kubrick, Martin Scorsese, and Francis Ford Coppola. A great qualification for working in a movie-hungry office. This demonstrates the kind of initiative that we like to see in the PI office. After graduating, Mike started working for the United States Telecommunications Training Institute, where he developed training programs in a variety of ICT issues for government and private sector leaders from developing countries. Mike's now in his final year as a student at Catholic University's Columbus School of Law, and he is a member there at the Institute for Communications Law Studies. We will turn to Allison Nemeth, if you wouldn't mind standing. Allison is also in her final year of law school at Catholic, where she's a senior editor on the Communications Law and Policy Journal. Allison is an up-and-comer. It took me until I was almost 40 to work at Verizon in the FCC's Office of General Counsel and in a commissioner's office. But Allison has managed to do all of this before graduating from law school. Allison grew up in West Hampton, New York, but she tells us that she never met any members of the Gossip Girl cast during her time in the Hamptons. I somehow doubt that, but we'll take her at her word for now. She earned her bachelor's degree in English from Lafayette College, where she was on the crew team. Now, instead of rowing, she gets her exercise from running and, I'm not making this up, the occasional triathlon. Just really impressive. So thank you, Allison. Last but not least, Michael Williams. He grew up in Atlanta, Georgia, and he stuck around to earn his bachelor's and master's in history from Emory University. After graduation, he traded the American South for the south of Spain and taught English in a village there for a year. While in Spain, he lived among the locals and fully embraced their customs, including, of course, the daily siesta and the 24-hour work week. At first, we were a little disturbed when Michael was just randomly napping in our office in the afternoon between 3 and 5, but we have gotten used to it. And I would add that, espero que puedo hacer lo mismo a veces en la futura. Michael is now at 3L at George Washington Law School, where he's an editor of the Federal Communications Law Journal. He says that he knows he is no longer in the South because the only decent fried chicken in D.C. is at a French restaurant. Thank you, all three of you, for working in our office this semester. We're glad you're here. Thank you, Madam Chairwoman.
I appreciate that. I also have several announcements, but before I do, Alex, you're missed already. Your poise and good nature, we've gotten so used to, and it's more rare than we like to admit. You added such a touch of class to an already classy agency, but your diligence and nose for good policy served us well. So again, thank you so very much, and we of course wish you all the best. In my office, there have been a couple of changes. Would like to welcome, if he would stand, David Valdez, who is serving as special counsel. He assists us with issues related to regulatory reforms and the facilitation of innovation in government, and of course in the managing of the various advisory committees of the FCC. He's held several policy positions both in the public and private sectors before joining us. Most recently as Senior Director for the Computing Technology Industry Association, and prior to that he was Verizon's VP in the Northwest region. David received his LLM in International and Comparative Law from Georgetown. He holds a JD from Rutgers School of Law and a Bachelor's of Arts from California State University. Thank you and welcome. I am also pleased to formally introduce to many of you my fall class of interns, and if you would stand, Brooke Johnson. Brooke received her undergraduate degree from Penn State, where she majored in broadcast journalism. Currently a 2L at Georgetown University Law Center, she has served as a student ambassador and worked with the Women's Legal Alliance. Welcome. Next, there's Justin Bell, who might... the virtual Justin Bell, who received his undergraduate degree from the University of Florida, where he majored in anthropology. He is currently a 3L, graduating in December at Howard University School of Law. He's a native of Miami, Florida, and enjoys basketball. I don't believe that, but you can quiz him later. And then there's Seth Williams, who's an LLM student at the Communications Law program at Catholic. He received his law degree and BA in journalism and political science from Indiana University in Bloomington. He's a native of Evansville, Indiana, where he started playing hockey at age 6. Welcome. At this time, I am pleased to announce the winners of the Commission's 2013 Excellence in Engineering Awards. This award recognizes Commission's engineers, scientists, and other technical staff for outstanding engineering, scientific, or technical contributions performed in the course of their work at the agency. We have 2 individual winners and 2 group awards to make today. The first winner is Timothy Harrington. As an engineer in OET's laboratory division, Tim has been instrumental in developing technical standards and policies to evaluate licensed signal boosters. Tim's efforts will ensure that these devices will soon be deployed to benefit wireless users everywhere. Thank you and congratulations, Tim.
Thanks.
Our second winner is Janet Young. There she is. Janet is an engineer in WTB's broadband division, was the lead engineer on the H Block team. Her work on that proceeding enabled the Commission to recently adopt rules for that long vacant spectrum. Her efforts will lead to additional mobile broadband spectrum availability, helping us to meet the nation's growing demand for spectrum. Congratulations, Janet. The third award goes jointly to Gregory Cunningham and Gary Westby from the Enforcement Bureau's Detroit office. Hello. I'm assuming you're watching. Hopefully you are. Gregory and Gary's technical study and the analysis regarding the 700 megahertz power flux density measurements along the U.S.-Canadian border led to establishing agreed-upon measurement techniques for future measurements of this type. Their important work in this area enabled the Commission to finalize a series of agreements with Canada, providing the means for U.S.-based wireless companies to operate in the border area. In addition, Gregory and Gary showed initiative by obtaining passage aboard a U.S. Coast Guard vessel, allowing them to take measurements in the Detroit River right at the international boundary. Thank you, Gary and Gregory. Would you? Yeah. Finally, recognize a group from the Public Safety and Homeland Security Bureau. Dr. John Healy, Julia Tu, Michael Kiafa, and Jerome Stanshine from the Stanshine? Okay. Stanshine. From the Derecho Technical Analysis Team conducted an inquiry into the communications failures, including the severe disruption to 911 service, which resulted from the derecho. Their efforts to identify the causes of the outages and recommendations on ways to make the public safer contributed directly to the FCC's critical mission to sustain communications at all times, with a particular emphasis on emergency communications. Their work in this area will go a long way towards safeguarding the public safety by ensuring that similar outages do not occur in the future. Thank you, John, Julia, Michael, and Jerome. Please thank them. Heartfelt congratulations to all of the winners, and keep up, of course, the good work. I am also pleased to announce the winners of the Federal Communications Commission's Excellence in Economic Analysis Awards. High-quality economic analysis is crucial to the agency's decision-making. This marks the 12th year of this award program designed to recognize the outstanding work of the Commission's economists. Nominations are open to any FCC staff person, and self-nominations are accepted. A committee that includes the chief economist, the deputy chief economist, and a representative group of other FCC economists evaluate the nominations and may select up to 5 winners each year. Evaluation criteria include impact on Commission policy and the significance of the contribution to the general base of knowledge in economics or public policy analysis. This year there are 2 awards with a total of 3 winners. Congratulations to Mark Bykowski and Bill Sharkey of the Office of Strategic Planning and Policy Analysis for their paper, Efficient Use of Radio Spectrum and Interference Limits. Congratulations. Thank you. And for his paper, Endpoint Joint Ventures in Differentiated Bertrand Oligopoly Theory and Application, And the related quantitative analysis he conducted as a part of the Commission's review of the ACS-GCI transaction, which involved a proposed joint venture between two Alaska wireless service providers. Congratulations are due to Alex Yankelevich. He will forgive me for that, but congratulations so much, Alex. I am also pleased to announce that the Industrial Organization Society recently announced that OSP economist Evan Kuehl will be the recipient of its 2014 Distinguished Service Award. The Industrial Organization Society is an international organization that promotes research on antitrust policy, regulatory policy, and competition and market power in real-world markets. Its annual Distinguished Service Award recognizes professional leadership in the scholarship and practice of industrial organizations. We are so proud of all of you. In this category, Mark, Bill, and Evan, on your accomplishments. Again, congratulations and keep up the good work. Please, another round of applause for all of our. What a great way to end a meeting. Again, thank you so very much. And so if there are no further announcements, Madam Secretary, if you would announce the date for the next FCC agenda meeting.
The next agenda meeting of the Federal Communications Commission is Tuesday, October 22nd, 2013.
Until then, we stand adjourned.
Testing 1, 2, 3. Check 1, 2.
gather for the chairwoman's press availability, please. And if I could remind you, we'll go along the table. It'll be the usual rules. One question. If you could just state your name and identify your media outlet, please. Paul, would you like to start?
Kirby with TR Daily. I asked you this the other day, but I wanted to get any more clarification on any contingency plan the FCC has in case there's a government shutdown. I know, folks that we cover probably want to get a sense for who might be here, who might be still working if there's a shutdown, and the impact on the agency.
Well, I am hopeful, of course, as is most of America, that we will not be faced with this. But if by chance this does occur, our Office of Managing Director has been working closely with the Office of Management and Budget to ensure that the proper procedures are followed. We will continue to support, of course, our staff and keep them informed. But again, we're engaged and we have a plan. Unfortunately, this is not the first time we've been faced with this, so we do have a plan that we are familiar with. But again, we're working with OMB to ensure that the proper processes are followed.
Hi, Alina Selyuk with Reuters. To follow up on that, can you give us an idea of how many staff members would be affected in this situation of a shutdown?
At this time, that would be a question probably a better director at our Office of Managing Director, and I will put you in touch with him if he is not in the room.
Chairwoman CLYBURN, can you talk at all about the Bloomberg agenda item that was taken off?
Well, as you know, that particular item was circulated in January. It was voted, so it came off the agenda. I can't be much more specific because it is a restricted proceeding, and I don't see the parties in the room, so I cannot discuss that. But until the order is finalized.
Brooks Bullock, Daily Hot Blast. I'm kidding, Politico. The grandfathering issue and the UHF discount, can you talk a little bit about that? Some of the broadcasters and Commissioner Pai seem to be really upset about how that works.
Well, again, the notice proposes to grandfather broadcast station ownership groups to the extent they will exceed the 39% national audience cap. It also proposes to grandfather station combinations for which an application is pending with the commission, or for those transactions that have received commission approval but not yet consummated. It also proposes to grandfather any ownership combinations subsequently sold or transferred that would require they would be required to comply with the national ownership cap that is in existence at the time of the transfer.
Bryce Bashik with Bloomberg BNA. Ms. Chairwoman, I wanted to also follow up on the UHF issue.
I'm sorry?
On the UHF issue.
Okay.
The grandfathering trigger, I wanted to get some clarification on when exactly that will be set.
Again, we've teed that up in the item. And so I don't know what else to say, but we've teed that up in the item and look forward to engagement from interested parties so we can move forward. So that's been teed up in the item.
Thank you. Can I just ask one more question about the grandfathering?
No.
No? I just
Probably not. I'll listen to you.
Okay.
Okay. Again, we've got some more folks. You have another opportunity. There's a gentleman behind you in a red tie who would be glad to follow up on that.
Thank you, ma'am.
Thank you.
We can start the Bureau press conference now. I think there were no requests for the wireless item. Is that right? So we should start with UHF discount, Media Bureau. No. Who's the question?
Bill. I'll shoot. Everybody wants to know about the grandfathering you look like a grandfather, So
I am as of this year. I'm very excited about it. Yeah.
So I do too. But tell us a little bit about when the trigger is in effect and that sort of thing.
Well, I should stress that this is a notice of proposed rulemaking, so nothing's been decided. But what is proposed in the notice is that existing groups that may exceed the cap by virtue of the elimination of the discount will be grandfathered. Combinations for which there's a pending application will be grandfathered, and combinations that may have been approved but not yet consummated will be grandfathered. All of that as of the date of the release of the notice of proposed rulemaking, which we expect to be released shortly. And then the second question, I think, was as to the back end. The proposal is that a grandfathered combination will remain grandfathered while it's in the same hands, but if it's sold, it would then be subject to the cap as the cap exists at the time of the transfer.
Will a grandfathered combination, that's not selling itself but is buying like one or two new stations, will it be able to do that, or will it have to seek a waiver to do that? Or
if it's grandfathered, it will be grandfathered for the holdings at the time of the NPRM. If it later seeks an acquisition that would put it over the cap, that won't be grandfathered.
And it's been a while since I looked at the law, but I was under the impression that the 39% cap that was written by Congress was pretty hard and fast. But you guys seem to be saying that it can be altered.
That's an open legal question. Our view is that the Congress set that number but left the Commission free both to change the cap and to change or eliminate the UHF discount.
Any further? Next item would be the Public Safety Bureau Network Resiliency. Any questions on that?
Yeah, I got.
Okay, Brooks does.
Hello, David. What information are you guys looking to collect exactly, and how is that going to be? The chairwoman mentioned that the reason to collect it was so that we, the public, could see what was going on in an emergency. So can you outline that a little bit?
Sure. The item, the NPRM seeks comment on what information should be collected. And the proposal is to collect daily during disasters when we would be activating partially or completely our DERS reporting system. The operating percentage for each wireless carrier by county in the disaster area. That's information that they provide daily during disasters today on a voluntary basis, and you can derive the percentages from that information.
What about the complaint that this is analogous to RG3's completion percentage for that Washington team?
There are, I think, 4 aspects to this. First, the effort is to make the information useful by coming up with a simple and clear metric that consumers can understand. The level of outages affects both coverage and capacity. Second, we've noticed that there are variations that are significant enough between the performance of carriers in the same counties faced with the same storm, served by the same electric company, that are not currently known to consumers. Third, the information is used by the federal government itself now to provide situational awareness to help direct FEMA and other kinds of responses. So the information is considered valuable by the federal government itself to provide situational awareness. And fourth, the carriers themselves cite this very metric, not necessarily by county, in talking during Sandy and at other times about how they're doing. They've said things like we're now have 90% of our sites operational as compared to 80% a few days ago, so we're doing better. So the metric is one the carriers use. It's one that's been useful to the federal government. It doesn't involve a significant burden on the carriers because the information needed is provided today, and it provides a simple and it potentially provides a simple and clear guide for consumers to use as a yardstick in making comparisons, and that may in turn spur carriers through the marketplace to try to improve their performance.
Thank you. Anything further? Thank you very much.